Hi everyone, this is Manvi Singh. I am a law student of IME Law College and I am a legal intern in Lexis and Company. So the topic is custody of child, gender neutral arena. So post-divorce or marriage annulment proceeding, the most viral and sensitive issues that arise are those that related to child custody. Child custody is a term used in a family court to define legal guardianship of a legal child of a child under the age of 18. There are various personal law or general law that deals with the matter regarding child custody in India, which include the Hindu Minority and Guardian Act of 1956, the Indian Divorce Act of 1869, and the Guardian and the Wards Act of 1890. Guardianship implies the priorities, all rights, and custodies implies the responsibility of raising a child. So, legal custody includes the right of the parent to make a decision which affects the welfare of a child. So, such as medical treatment, religious practice, and insurance claim. Physical child custody places the crime responsibility on parents for the child housing, education, and food. In most cases, the non-custodial parent still are visitation rights. So, what is the origin of this topic? The concept of custody and guardianship as enshrined in the Indian legal system can be traced to English law, specifically the Guardian and Wards Act 1890, from where the Hindu Guardianship and Minority Act is derived from. When the divorce was guaranteed, wives challenging the natural guardianship of their husband came into the public discourse. Court in England started diversity judgment based on the principle that matrimonial litigations is not to be punished the guilty but only to ensure the welfare of child. This gave the way of the concept of welfare of child being a paramount consideration is custodial matter. So now the another one is criteria for determining custody of minor children. So the court, while exercising it, the petri jurisdiction takes into the consideration a variety of factors in selecting a custodian. They are bound to give due to importance to the child ordinary comfort, containment, health, education, intellectual development, moral, ethical ties of affections, and favorable surrounding. So the modern development of family law has been diverted from the concept of treating children as merely chattel and has been progressed toward a more inclusive approaches giving due to importance to the preference of the child. Section 26 of the Hindu Marriage Act provide for the wishes of the child to be made consistent with order in relation to custody whenever possible. So now, another one is the factor listed out hierarchical orders of importance are. So there are some welfare of children which is of paramount consideration. Wishes of the parent, wishes of the child, and age and sex of the child. So now the welfare of the children. One of the most well settled propositions in family law is to secure the child paramount welfare in matter relating to the custody. However, what constitutes welfare has had widely different interpretation. The Bombay High Court, in the cases of Garla Canon versus Shahbaz Farooq Al-Haraki, held that the children's welfare was the supreme consideration, irrespective of the rights and the wrongs that the parent contended. The Supreme Court has further held that the welfare of a child is not to be measured merely by the money or physical comfort, but the word welfare must be taken in its widest sense. The ties of affection cannot be disregarded. Now, the conclusion of this topic is, through seemingly it might appear like India is approachingly a more gender-neutral arena in the term of custody law. The various aforementioned judgments are not absolute in awarding the statutes of custodian to the mothers, and they are qualified by the certain prerequisites, such as when it's were mutual decided when between the parents, and that the mother will act as the guardian. So guys, this was all about this topic. Thank you so much for listening me. Like, comment and share.